In this penultimate lesson examining the actus reus of an offence, we're going to start to talk about the concept of causation. We're going to talk about causation in two lessons specifically. We'll talk about it here generally, talking more about causation in fact, and then we will talk about the concept of legal causation or causation in law in the next lesson, as well as the concept of intervening causes within a particular act, which could potentially negate criminal liability. So ultimately, this means essentially that we're asking the question of, do the acts which are considered to be unlawful causally lead to the harm which resulted? And that question is one which is important for those who are trying to establish the actus reus of an offence. But it's only important for certain crimes. Specifically, it's only important for result crimes. Causation is a principle, of criminal law which will only apply to a result crime. It will only apply to those kinds of crimes. A result crime is simply one which requires a particular end result to occur as a result of the criminal conduct. This makes perfect sense. So, for example, murder is a result crime since it requires the death of the victim. If the person doesn't die, then it can't be murder. As simple as that, unfortunately. And at the end of the day, there may exist other kinds of crimes that exist. So, for example, conduct crimes. A conduct crime is one whereby an individual exhibiting a particular criminal behavior may be guilty of an offence regardless of whether or not that particular crime results in some kind of end state. So driving a vehicle whilst dangerous, whilst without insurance, or driving a vehicle dangerously. These are both conduct crimes. These are crimes that you don't need to have there have been a result that causes criminal liability. Driving a vehicle dangerously doesn't necessarily have to result in an accident or someone getting run over or some kind of damage. It could just be driving dangerously, at which point you have already satisfied the liability within criminal law. Similarly with driving without insurance. You may drive from point A to point B without insurance and it be a completely innocuous and perfectly reasonable vehicle journey where nothing bad happens, but you would still be committing an offence in the sense that the mere act of driving without insurance is where the criminal liability arises. So, causation only applies to result crimes, and of course the reason why this is the case is because there has to be a harm caused by the unlawful conduct, and this harm has to have been caused by the defendant who is charged with the offence. So let's think about causation in a bit more detail, and we're going to begin with something known as the but-for test. This is the first question that we ask when we talk about how to determine causation, and we're going to get into this in more detail as well when we look at causation relating to the law of tort, because a number of the similar principles exist across both tort and criminal law in this regard. So the question is, how do we determine causation? Well, we first have to make a delineation between causation in fact and then also causation in law. These are things that we're going to look at, firstly in fact in this lesson and then in law in the next. But essentially, causation in fact is a factual matter. Did the defendant cause the event to take place? Causation in law takes account of the fact that while the defendant's conduct may be a cause, is it enough to meet and merit the liability for the legal cause? And so essentially what we have to do is take into account what are known as intervening causes, new intervening causes, because for the most part, unfortunately, the world is a lot more complicated than we would like it to be, and a lot of acts that are caused may be caused by multiple different factors. They may be multiple different causes for one single event. And so to really determine whether or not there is accountability in that regard, we have to think about these new intervening causes and the extent to which they contributed to the event taking place. So there may be instances where there are other factors which intervene, and as a result there is more than one cause, and so as a result there is the question of where liability actually sits in relation to certain events which take place. But causation in fact is determined by the but-for test. So the but-for test essentially asks us to examine this question. Essentially, but for the conduct of the defendant, would the result have happened? The result which gives rise to criminal liability. So essentially, if it wasn't for the conduct of the defendant, but for the conduct of the defendant, would the result have happened? If the answer is no, then we can say that the defendant caused the result. Because if we say, well, if it wasn't for this conduct, would the result have happened? And the answer is no, then that tells us that the conduct of the defendant causes the action, and therefore we would say that D caused the result. If the answer is yes, if the defendant can be taken out of the situation completely, and the same result would have still happened, okay, the result that gives rise to criminal liability, then this means that the defendant did not cause the result, okay? And the very famous case that we can look to is from 1910, the case of Aon White. And this tells us and shows us how causation is applied in law. It's an incredibly interesting set of facts. Ultimately, in this case, the defendant wanted to murder his mother, okay? And he attempted to do so by putting cyanide in her drink. His mother then had drank some of the drink, but then died from a completely unrelated instance of heart failure. You can't make it up. And ultimately, the medical evidence in the trial showed that the cyanide wasn't the cause of death of the defendant's mother. In fact, the victim died of a completely unrelated incident, and just by pure luck was this at the same time that the defendant had put the cyanide in her drink. And so as a result of which, the defendant wasn't the cause of the death of the mother. So while he was convicted of attempted murder, which doesn't require the death of the victim, it just requires the intent and an action which goes a long way to the murder itself. He could not have been convicted of the murder fully, because if we were to apply a strict application of the but-for test, we would say, well, but for the actions of the defendant, would the victim still have died? And the answer to that question is yes, because if the defendant hadn't have put the cyanide in her drink, then the mother would have still died from this completely unrelated instance of heart failure. And so as a result of which, you cannot argue that the defendant was the cause of the death, even if he wanted to be the cause of the death or intended to murder his mother. A similar instance comes from 2018, a little bit more complicated, this case, the case of Wallace. Ultimately, the facts of this case determine really where the Court of Appeal stood on this issue. In this case, the defendant was the ex-girlfriend of the victim. They had broken up, and following the breakup and the ex-boyfriend forming a different relationship, the defendant then decided to attack the victim with acid. Okay, I believe famously saying, "If I can't have you, no one can," something like that, and then throwing this very strong acid onto the defendant. The medical testimony of the effect of this acid isn't a particularly fun read, so I wouldn't recommend it. But ultimately, when throwing the acid on the victim was left disfigured, completely paralyzed, in a state of physical and psychological pain. I believe completely blind as well. Completely in a state of physical and psychological pain. The acid attack was actually so damaging that, despite the fact that there were extensive surgeries and extensive medical treatments that had taken place on the victim to try and alleviate some of this pain and to try and alleviate the condition that he was in, he made the decision to go and travel to Belgium, where euthanasia is illegal, and took his own life. So legally killed himself as a result of the attack that had happened, or at least allegedly as a result of the attack that had happened. Now, the defendant's legal counsel argued, because ultimately the attack itself was a criminal offence. It would have been presumably GBH with intent, or even attempted murder, but then it was transformed into a new offence now, where she's now being charged with murder, because now the defendant had died as a result of her attack. Then we have this new instance where, okay, well, can the defendant in this case be charged with murder? Does the chain of causation exist? According to the legal counsel of the defendant, they argued that the doctor's injection, which legally euthanized the victim, had constituted a novus actus interveniens, which is just Latin for a new intervening cause of the death. and that the trial judge, when the trial judge withdrew the case of murder on the basis of this new intervening cause, the prosecution appealed, and the Court of Appeal would allow the case of murder to be tried. Ultimately, what was done is the issue of murder was given to the jury to determine whether or not causation can be found for the charge of murder, given that the decision to take his own life was one that was made by and influenced by the attack itself. So even if the defendant's legal counsel argued that, well, the injection itself is a new intervening cause, was the decision to take his own life one that was influenced by the attack? Obviously, the answer to this question is yes.